Arizona Supreme Court Rule 81, Rules of the Supreme Court. The preamble to the Arizona Code of Judicial Conduct. Its promises, strengths, and weaknesses. This is my personal examination of the preamble to the Arizona Code of Judicial Conduct. My purpose is not to claim that every judge is dishonest or that every judicial decision is improper. My purpose is to read the words carefully and ask what they promise, what they actually require, and what important protections for the public are missing. What is a preamble? A preamble is an introductory statement of an important document which ordinarily explains the document's purpose, principles, and general philosophy. A preamble usually helps understand the provisions that follow, but it normally does not provide detailed procedures or enforcement mechanisms. In simple language, the preamble tells us what the Arizona Code of Judicial Conduct claims to stand for. It therefore creates the first impression of the relationship between judges, the law, and the public. The promise of a trustworthy judiciary. Preamble begins with an impressive statement. An independent, fair, and impartial judiciary is indispensable to our system of justice. It describes the judiciary as independent, impartial, competent, and composed of men and women of integrity. These are strong and appropriate ideals. An independent judge should not be controlled by improper outside influence. A fair and impartial judge should not favor one party over another. A competent judge should possess the knowledge and ability necessary to perform judicial duties. A judge with integrity should be honest, upright, and worthy of the authority entrusted to that office. This section describes judicial office as a public trust. That is one of its strongest statements. A public trust does not belong personally to the judge. Judicial authority is entrusted to the judge for the benefit of society. Then preamble commands that judges, individually and collectively, must respect and honor that trust and strive to maintain and enhance confidence in the legal system. Thus, the preamble identifies the qualities the public should expect from judges. It recognizes that judicial authority carries responsibility, and it connects the legitimacy of the judiciary with public confidence. However, there are serious weaknesses in most of the statements above. Preamble describes what judges are expected to be, but it provides no method for verifying that individual judges actually possess these qualities. There is no mention of periodic examination of judicial conduct. There is no requirement that a judge's complete professional record be available for public review. There is no explanation of how independence, fairness, impartiality, competence, or integrity will be measured. The preamble therefore asks the public to accept a description of the judiciary without explaining how the public can determine whether that description is accurate. It also says that judges will interpret and apply the law. This wording clearly places judicial interpretation above the written law and its practical application. Interpretation must not be necessary, but the preamble does not explain the limits of interpretative authority. It does not say how closely an interpretation must follow the actual words of the law. It does not explain who determines whether an interpretation remains faithful to the law. And it does not identify any immediate mechanism for correcting an interpretation that contradicts the law and harms a litigant. The start of preamble therefore presents a powerful promise. Judges of integrity will interpret and apply the law as holders of a public trust. Its weakness is that the promise depends almost entirely on confidence in the judges themselves. What judges should do. The preamble declares that judges should maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety. It then says judges should aspire to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. The strength of this statement is that it extends ethical expectations beyond the courtroom. It refers to both the professional and personal lives of judges. It also recognizes that actual impropriety is not the only concern. The appearance of impropriety can also damage confidence in the judiciary. That is a valuable principle. A judicial institution cannot preserve confidence merely by saying that misconduct was not conclusively proved. Public officials must also avoid conduct that reasonably appears dishonest, biased, improper, or inconsistent with their responsibilities. But the key word in this statement is should. It does not say that judges must maintain the dignity of judicial office. It says they should. It does not say that judges must ensure the greatest possible public confidence. It says they should aspire to conduct that ensures it. To aspire means to aim for something. It does not mean that the objective was achieved, and there is no consequence for failing to achieve it. The preamble does not define impropriety. It does not establish a test for the appearance of impropriety. It does not identify who will investigate questionable conduct. It does not require the publication of information needed for public scrutiny. And it does not explain what happens when a judge ignores these aspirations. The preamble, therefore, contains a strong ethical message but weak language of obligation. It tells judges what they should seek to accomplish, while leaving unanswered whether anyone will verify that they actually do so. Guidance and the first mention of discipline. This code establishes standards for the ethical conduct of judges and judicial candidates. It then says the code is not intended to be an exhaustive guide. Judges are also said to be governed by general ethical standards, although those additional standards are not identified in the preamble. The preamble describes two purposes of the code. First, it is intended to provide guidance and assistance to judges in maintaining the highest standards of judicial and personal conduct. Second, it is intended to provide a basis for regulating judicial conduct through disciplinary agencies. The first purpose is plainly advisory. The code provides guidance and assistance. That can be useful because judges may face ethical questions that require careful consideration. The second purpose is potentially stronger. For the first time, the preamble recognizes that judicial conduct may be regulated through disciplinary agencies. This is an important strength. It confirms that the code is not intended to be merely ceremonial. It is supposed to provide at least a foundation for judicial discipline. But the language remains limited. The code provides a basis for regulation. The preamble does not say that every violation will be investigated. It does not say that every established violation will produce discipline. It does not describe the authority, independence, composition, or procedures of the disciplinary agencies. It does not give complainants any procedural rights. It does not require interviews, evidence collection, written findings, public hearings, or meaningful explanations for dismissals. It does not provide immediate protection for a person who is being harmed by judicial conduct while a case is still active. This last omission is especially important. A reprimand issued months or years after an improper judicial act may affect the judge's record, but it may provide no meaningful help to the injured litigant. It cannot necessarily restore lost time, money, liberty, reputation, evidence, or opportunity. Accountability after the harm is not the same as prevention while the harm is occurring. Conclusion. The preamble contains worthy principles. It describes judges as independent, fair, impartial, competent, and guided by integrity. It recognizes judicial office as a public trust. It tells judges to avoid impropriety and its appearance. And it acknowledges that disciplinary agencies have a role in regulating judicial conduct. Those are its strengths. Its weakness is that nearly everything depends on expectation, aspiration, guidance, and confidence. The preamble tells the public why judges should be trusted, but it does not explain how that trust will be verified. It says judges interpret and apply the law, but it does not define the limits of interpretation. It says judges should avoid impropriety, but it provides no enforcement mechanism. It mentions disciplinary agencies, but it does not explain how they will investigate complaints, prevent ongoing harm, or remain independent from the institution they regulate. The preamble, therefore, describes an ethical ideal. But an ethical ideal becomes meaningful public protection only when it is supported by transparency, verification, timely intervention, and enforceable responsibility. Public confidence should not be requested merely because judicial office is called a public trust. Public confidence should be earned by allowing the public to see whether that trust is being honored. The final question is therefore simple. If judges must expect public scrutiny, where is the information that allows the public to perform that scrutiny? And if judicial conduct violates the principles announced in this preamble, what mechanism protects the person being harmed while protection can still make a difference?